This is big.
It triggers something in me that something has to be done.
The Second Amendment protects the right to carry a gun in public for self-defense.
The Supreme Court today handed down a major victory for gun control advocates.
Now, this is the most significant Second Amendment ruling in more than a decade.
The Supreme Court just delivered a ruling that almost nobody saw coming. It is the kind of decision that happens once in a generation, if that. 9 justices who rarely agree on anything set aside ideology and issued a unanimous opinion that directly reshapes how police use deadly force against American citizens. And if you legally own a firearm, this ruling quietly became one of the strongest legal protections you have ever been given. While the media was consumed with political theatrics and headline-driven outrage, the highest court in the country rewrote the framework governing police encounters with armed civilians. This was not a procedural clarification or a narrow technical fix. It was a direct repudiation of how courts have evaluated police shootings for decades. The implications are sweeping, and most people still have no idea it happened. Under that standard, courts asked only one question: did the officer feel threatened at the exact moment deadly force was used? If the answer was yes, the analysis stopped there. Everything else was treated as irrelevant. It did not matter how the encounter began. It did not matter whether the officer escalated the situation. It did not matter whether safer alternatives were available. The entire interaction was reduced to a single snapshot in time. You do not need to be a legal scholar to see how dangerous that approach is. It rewarded reckless decision-making. An officer could create chaos through poor tactics, place themselves in danger unnecessarily, and then rely on that danger to justify lethal force. Courts would ignore the buildup. They would ignore the officer's choices. They would ignore opportunities to step back, slow down, or de-escalate. The law cared only about fear in the final second. For years, that was enough. The Supreme Court decided it was no longer acceptable. In a unanimous opinion that stunned legal analysts, the court rejected the moment of threat framework entirely. Writing for all 9 justices, Justice Elena Kagan made it clear that courts must now evaluate police shootings based on the totality of the circumstances. Not just the last second, not just the officer's subjective fear, the entire encounter from start to finish. To understand why this matters so much, you have to look closely at what actually happened during the Barnes traffic stop. When Officer Felix pulled Barnes over, Barnes initially complied. He opened his door. He began to step out of the vehicle. Then something changed. Barnes attempted to get back into the car and drive away. At that moment, Officer Felix made a critical decision. Instead of stepping back, he jumped onto the door frame of the moving vehicle. Within 2 seconds of the car starting to move, the officer fired 2 shots into the vehicle, killing Barnes. Under the old legal framework, that was the end of the story. The officer was in a moving car. He perceived danger. Deadly force was automatically justified. That is exactly how the lower courts ruled. Both the trial court and the appellate court focused exclusively on those 2 seconds when the vehicle was moving. They treated everything before that point as legally irrelevant. The Supreme Court did not. The justices asked questions that the old doctrine had effectively banned. Why did the officer jump onto the car? Was that decision necessary? Was it reasonable? Could he have stepped back instead? Was Barnes attempting to harm the officer, or was he attempting to flee? Did the officer's own actions create the danger he later claimed justified lethal force? Those questions fundamentally change the analysis. They force courts to evaluate responsibility, judgment, and proportionality. They recognize that constitutional rights cannot be suspended simply because an officer made a poor tactical choice and then felt afraid as a result. The court's message could not have been clearer. You cannot isolate a fraction of a second and ignore the rest of reality. The Constitution demands a full accounting. Every action matters. Every decision matters. Every escalation matters. This ruling is not just about fairness in police shooting cases. It is about restoring constitutional limits on state power. It reasserts that the Fourth Amendment requires reasonableness throughout an encounter, not just at the moment force is applied. If you think this only affects cases involving police misconduct, you are missing the broader impact. This decision directly strengthens the legal position of law-abiding gun owners during police encounters. Gun owners are disproportionately likely to interact with law enforcement. Traffic stops where firearm disclosure is required. Welfare checks prompted by complaints. Encounters near ranges or hunting areas. In all of these situations, The presence of a firearm introduces risk, not because the owner is dangerous, but because misinterpretation can escalate rapidly. Under the old standard, lawful gun ownership could become a liability in seconds. An officer sees a legally carried firearm. Tension rises. Commands are shouted. Movements are misread. Fear spikes. That split second of fear could legally justify force, regardless of whether the gun owner had done anything wrong. The new standard changes that calculus. Courts must now examine the entire interaction. Did the gun owner comply with disclosure requirements? Did they follow instructions? Did they move deliberately and clearly? Did the officer escalate the situation unnecessarily? Did the officer misinterpret lawful behavior as a threat? All of that now matters. This ruling makes it far more difficult for law enforcement to rely on fear alone as a legal shield when their own actions contributed to the danger. It also means that your lawful behavior as a gun owner is no longer legally invisible. Your compliance, your communication, and your restraint become part of the constitutional analysis. This is where the Second and Fourth Amendments intersect in a way the court has never articulated so clearly before. The right to bear arms does not dissolve Fourth Amendment protections. Lawful possession of a firearm does not suspend the requirement that police conduct be reasonable from start to finish. Being shot by police is the most extreme form of seizure imaginable. The Supreme Court has now made clear that such a seizure cannot be justified by cherry-picking a single moment while ignoring the path that led there. The implications do not stop at the courtroom. Police departments across the country will be forced to rethink training and tactics. The old fallback defense of "I feared for my life" is no longer enough on its own. Officers will need to justify the entire sequence of decisions that led to the use of force. Why did they approach the way they did? Why did they escalate? Why they failed to disengage? For gun owners, this ruling offers stronger protection, but it also demands discipline. The totality of circumstances applies to you as well. Your conduct will be scrutinized. Calm communication matters. Clear compliance matters. Knowing and following your state's disclosure laws matters. Legal scholars are already calling this the most consequential Fourth Amendment decision in decades. Some compare its potential impact on policing to Miranda rights. The difference is that Miranda became common knowledge. This ruling has barely been discussed. Most Americans do not realize that their constitutional protections were just reinforced in a meaningful way. And the fact that all 9 justices agreed sends a powerful signal. This is not a fragile ruling hanging by a thread of ideology. It is settled constitutional law. Lower courts are not free to ignore it. Police departments are not free to dismiss it. What happens next is where this ruling begins to alter the legal landscape in real and lasting ways. Attorneys who represent victims of police shootings are already reevaluating cases that were previously considered unwinnable. Under the old framework, many claims died before they ever reached a jury because courts refused to look beyond the final second of fear. That barrier is now gone. Cases that were dismissed on summary judgment may be reopened. Incidents once written off as unavoidable tragedies may now be examined for what they actually were. A chain of decisions, some reasonable, some reckless, all of which contributed to the outcome. The law no longer allows courts to pretend that the lead-up does not exist. Predictably, police unions and law enforcement organizations are pushing back. Their argument is familiar. They claim that requiring officers to account for earlier decisions will make policing more dangerous. They argue that hesitation could cost lives. But the Supreme Court addressed this concern directly, even if not in so many words. Constitutional rights are not suspended because enforcement is difficult. The Fourth Amendment does not contain an exception for convenience or fear. It demands reasonableness. And reasonableness requires context. The court is not asking officers to be perfect. It is asking courts to stop pretending that bad decisions vanish the moment an officer becomes afraid. This distinction matters deeply for gun owners. For decades, lawful firearm possession existed in a gray zone during police encounters. Technically legal, but practically risky. A holstered weapon could transform a routine stop into a tense confrontation. A misunderstood movement could escalate into commands, drawn weapons, or worse. The law offered little recourse because fear, once claimed, overrode everything else. Now the analysis is broader and more balanced. If you are legally carrying and properly disclosed when required, that matters. If you follow commands carefully and avoid sudden movements, that matters. If an officer chooses aggressive tactics that heighten risk rather than reduce it, that matters too. Courts are required to weigh all of it. This ruling does not guarantee outcomes. It does not mean every police shooting will be deemed unconstitutional. What it does mean is that courts can no longer rubber stamp deadly force by isolating a single incident and ignoring the full encounter. This also places a new emphasis on documentation and awareness. For civilians, especially gun owners, understanding your rights has never been more important. Knowing when and how to disclose carry status. Understanding what commands are lawful. Remaining calm and deliberate even under stress. These factors now carry legal weight in ways they previously did not. From a training standpoint, police departments will be forced to adapt. Officers will need to justify not only why they fired, but why they approached the situation as they did. Why did they position themselves in harm's way? Why did they choose escalation over distance or cover? Why did they interpret lawful behavior as threatening? This is a fundamental shift. It encourages better tactics and discourages reckless ones. It aligns constitutional law with common sense. Creating danger should not be rewarded. Avoiding it should not be punished. Legal analysts are already predicting ripple effects beyond shooting cases. The totality of circumstances standard may influence how courts evaluate use of force more generally. Tasers, baton strikes, physical restraints. Any encounter where force is used may now require a more complete examination of the lead-up. That has implications for accountability across the board. What makes this decision especially powerful is its unanimity. In an era where nearly every major ruling is split along ideological lines, this one was not. Conservative justices, liberal justices, appointed by presidents from opposing parties, all agreed that the old framework was constitutionally insufficient. That unity sends a message to lower courts. This is not optional. This is not a suggestion. This is the law. It also sends a message to citizens. Constitutional protections are not static. They weaken when courts tolerate shortcuts. They strengthen when courts demand rigor. In this case, the Supreme Court chose rigor. For everyday gun owners, this ruling should prompt a shift in mindset. You are not powerless during police encounters, but neither are you immune from scrutiny. The totality of circumstances cuts both ways. Courts will examine your actions as well as the officers. That means sloppy behavior, poor communication, or failure to follow lawful instructions can still undermine your position. The ruling protects responsible conduct. It does not excuse recklessness. This is where many people get complacent, and it is a mistake. Stronger rights require smarter behavior. Calm tone, clear statements, deliberate movements. These are not just safety practices. They are now legally relevant facts. Another critical point that has received almost no attention is how quietly this ruling was issued. There was no wall-to-wall coverage, no emergency press conferences, no viral outrage cycle. The decision landed while the public was distracted, and that is not accidental. Major constitutional changes often happen this way, not with fireworks, but with footnotes and legal reasoning. While people argue about headlines, courts reshape the rules underneath them. Ask yourself how many gun owners you know who are aware of this decision. How many will walk into their next police encounter unaware that courts are now required to look at the full context? How many will unknowingly undermine their own legal protection by acting carelessly or failing to communicate clearly? Ignorance does not negate rights, but it often prevents people from exercising them effectively. This ruling also underscores a broader truth. Constitutional rights are interconnected. The Second Amendment does not exist in isolation. Neither does the Fourth. When courts treat one right as a justification to erode another, everyone loses. The Supreme Court made clear that lawful gun ownership cannot be treated as a constitutional shortcut for unreasonable force. This restores balance to a system that had drifted too far in one direction. It does not demonize police. It does not glorify violence. It simply demands that power be exercised responsibly and reviewed honestly. Looking forward, this decision will influence thousands of cases. Some quietly, some publicly. It will shape training manuals. It will alter legal strategies. It will change how judges instruct juries. Over time, it will change behavior. That is how constitutional law is supposed to work. The Barnes versus Felix decision is ultimately not about one man, one officer, or one traffic stop. It is about whether courts are willing to confront uncomfortable truths, whether they are willing to admit that legal doctrines designed for convenience can erode fundamental rights. 9 justices answered that question clearly. The Constitution requires more than fear. It requires judgment. It requires accountability. It requires context. And for the first time in decades, The law now reflects that reality. As this ruling begins to filter through the legal system, its long-term significance will become clearer. Some changes will be immediate. Others will take years to fully materialize. But make no mistake, this decision permanently alters the relationship between citizens, law enforcement, and the Constitution. One of the most important effects will be seen in how judges evaluate credibility. Under the old framework, an officer's statement that they feared for their life often ended the inquiry. Courts were reluctant to second-guess split-second decisions, even when those decisions followed questionable tactics. That difference is no longer automatic. Now, fear must be examined, not simply accepted. Judges must ask whether that fear was reasonable in light of everything that happened before it. They must consider whether the officer's own actions contributed to the danger. They must weigh whether alternatives existed and whether they were ignored. That is a profound shift. It also restores the role of juries in cases that previously never reached them. When courts limited analysis to a single moment, many cases were dismissed before a jury ever heard the facts. By requiring full context, the Supreme Court has reopened the door to public accountability through the justice system. This does not guarantee verdicts. It guarantees a process, and process is the backbone of constitutional protection. For police departments, adaptation will be unavoidable. Training will need to emphasize distance, cover, and de-escalation in ways that were previously optional. Officers will need to understand that creating danger is no longer legally invisible. Tactical decisions will be scrutinized not just internally, but in court. Some departments will resist. Others will adapt quickly. History suggests that those who adapt will see fewer tragic outcomes and fewer lawsuits. Accountability and safety are not opposites. They are aligned. For gun owners, the lesson is equally clear. Rights are strongest when exercised responsibly. This ruling rewards lawful behavior, clear communication, and measured responses. It penalizes chaos, escalation, and poor judgment on both sides of the encounter. If you carry legally, you must know your state's disclosure requirements. You must understand how to communicate your status without creating an alarm. You must be disciplined enough to move slowly, speak clearly, and follow lawful instructions even under stress. None of that is new advice. What is new is how much legal weight it now carries. Your actions no longer disappear from the record simply because an officer later claims fear. They become part of the constitutional analysis. That is both a protection and a responsibility. Another underappreciated aspect of this ruling is how it reframes public debate. For years, discussions about police shootings have been polarized and unproductive. One side focused exclusively on officer safety. The other focused exclusively on civilian harm. The court rejected that false choice. The totality of circumstances framework recognizes that safety and rights are intertwined. Good policing reduces danger. Reckless policing increases it. Lawful behavior by citizens reduces risk. Unclear or erratic behavior increases it. The law now reflects this reality instead of obscuring it. This decision also reinforces a critical principle. Constitutional rights are not suspended during moments of stress. In fact, those are the moments when they matter most. If rights only apply when things are calm and predictable, they are meaningless. By demanding context, the Supreme Court reaffirmed that constitutional scrutiny does not end when tension begins. As future cases cite this ruling, its influence will expand. Attorneys will reference it in motions. Judges will rely on it in their opinions. Training academies will incorporate it into curricula. Slowly but decisively, standards will change. And yet, most Americans will remain unaware unless they actively seek this information. That is the quiet danger of constitutional law. It operates beneath the surface. Those who stay informed gain protection. Those who do not may never realize what has changed until it is too late. This is why understanding your rights is not optional. It is not political. It is practical. It affects how you live, how you interact with authority, and how you protect yourself legally as well as physically. The Barnes versus Felix ruling stands as a reminder that courts can correct course when doctrines drift too far from constitutional principles. It shows that unanimity is still possible when the issue is fundamental. It demonstrates that the Constitution is not frozen in time, but actively interpreted to meet real-world consequences. 9 justices looked at a system that prioritized convenience over completeness and rejected it. They insisted on a standard that reflects reality rather than distorting it. They restored balance where imbalance had become routine. Whether you are a gun owner, a civil liberties advocate, or simply someone who believes that government power must have limits, this decision matters. It affirms that context matters, that judgment matters, that rights matter, and it sends a message that should not be ignored. The Constitution does not protect outcomes. It protects the process. It demands that power be justified, not assumed. It requires that courts look at the whole truth, not just the convenient fragment. In a deeply divided era, that is a rare and meaningful statement. That is all for today. Stay informed, stay disciplined, and understand the rights that quietly just became stronger. See you in the next one.